139 days after polling day, election results seem no closer to finality. On Monday afternoon, giving her ruling in the court action which challenged the Elections Commission's decision to invalidate the declarations made by the returning officers in the country's 10 electoral districts and the use of certificates of recount as the basis for the declaration of the election results, Chief Justice Madam Roxanne George dismissed the application filed at the High Court in the case of Misenga Jones.
I am bound to follow the decisions of the Court of Appeal and ultimately the Apex Court, the CCJ. The application is accordingly dismissed.
The Chief Justice in her ruling indicated that Order 60 of 2020, which gave life to the national recount exercise, cannot be deemed as invalid. She relied on the ruling of Ghana's Apex Court, the Caribbean Court of Justice, and pronounced that the matter is res judicata, which means that the matter has already been adjudicated by a competent court and therefore cannot be pursued further.
Thus, both courts by which I am bound have pronounced on this issue. This court, therefore, cannot rule that Order 60 is invalidated. This issue is therefore res judicata.
Attorney at law Roysdale Ford for the applicant, Misenga Jones, following the ruling by the Chief Justice, indicated his client's intention to file an appeal on Tuesday at the Court of Appeal. He had asked that the CEO as well as chairperson of GCOM continue to await the pronouncements by the court before proceeding with any declaration or otherwise official business that would seek to interfere with court proceedings.
In the circumstances, Your Honor, whilst we are not required to seek the court's leave to appeal to the Court of Appeal under Article 133, Your Honor, we wish to inform the court and the parties that we intend to so file an appeal to the Court of Appeal.
Madam Roxanne George, in delivering her ruling, also highlighted the fact that the CEO is subject to the control and direction of GCOM and not vice versa, while also pointing out that Mr. Lowenfield cannot act in isolation. The Chief Justice had also deemed the reliefs sought by the applicants to be litigated, as she pointed out that a number of those reliefs are mirrored in previous cases at the various courts and therefore are deemed to be res judicata. Madam George had also pointed out that there are a number of matters and conflicts to be addressed and resolved by GCOM. Reporting for HGP Nightly News, Wendell Badrie.